Hello and welcome to S&C's Critical Insights. I'm Kamil Shields, a partner in the firm's litigation group and a member of the criminal defense and investigations group at Sullivan & Cromwell. Joining me today is Mehdi Ansari, the co-head of Sullivan & Cromwell's intellectual property group and the artificial intelligence practice.
Hi, Kamil. It's great to join you.
I am really looking forward to our discussion today, Mehdi. Today is the final episode of the Critical Insights series on a range of whistleblowing developments that have been impacting our clients. We will have a wrap up, but this is our final substantive topic. In our previous episode, our partners Annie Ostrager and Nick Borton were partners in the firm's litigation group, discussed whistleblowing trends under the DOJ corporate pilot program, among other developments. If you missed that episode or any of the episodes in this series, again, I recommend them all. You can find them in the S&C Critical Insights library. Today, we'll discuss some recent events at the intersection of artificial intelligence and whistleblowing. We'll touch on the AI Whistleblower Protection Act, which was proposed this past spring. And then we'll explore some differences in AI-related executive orders between the prior and current presidential administrations. Finally, we'll describe a recent, quote, AI washing case. Sabrina Solow, an associate in our litigation group, will continue to moderate the discussion. She's been an excellent moderator to date. And with that, Sabrina, I'll turn it over to you to get us started.
Thanks so much, Kamil. It's great to speak with you both today about this very hot topic. Let's dive right in. Mehdi, could you please describe the recent legislation to protect AI whistleblowers and how that came about?
Thanks, Sabrina. Sure. As I'm sure our listeners know, artificial intelligence has been developing rapidly in the past few years and has impacted nearly every corner of society, from education to legal services to healthcare. And with that rapid expansion has come concerns about risks, security breaches, and other legal or ethical violations associated with AI development and deployment. And the related concern that employees working for AI companies or otherwise in the AI space may not have adequate protection should they wish to speak up about something they're seeing that's wrong. And employees may not be empowered to come forward with that information, in particular because of employment agreements or restrictive NDAs. So in May, the Senate Judiciary Committee Chair, Chuck Grassley, introduced a bipartisan piece of legislation called the Artificial Intelligence Whistleblower Protection Act. That bill comes on the heels of commentary from Senator Grassley and others expressing concern that employment and non-disclosure agreements may be preventing employees of AI companies from making protected disclosures to government regulators. In June 2024, about more than a year ago, there was an open letter by 13 AI employees, many of whom chose to remain anonymous, who claimed that there were inadequate protections in place for AI employees. Specifically, they cited that there are serious risks posed by AI technologies, including the further entrenchment of existing inequalities, manipulation, misinformation, or even potential for the loss of control of autonomous AI systems, which could result in human extinction. But the employees also explained that the existing whistleblower protections, such as those in Sarbanes-Oxley and Dodd-Frank, were insufficient because those protections often focused on illegal activity. And because AI regulation is still maturing, many of the risks associated with AI development are not yet regulated to the point where they could be deemed necessarily illegal. And as a result, the whistleblower protections under existing laws may not give protection to the employees to make disclosures about what they see in AI companies.
Thanks, Mehdi. Kamil, what would Senator Grassley's proposed AI Whistleblower Act do?
Thanks, Sabrina. Unlike some of the other regimes that we've discussed in prior episodes in the series, the proposed legislation doesn't purport to provide a large monetary reward for whistleblowers. That's something that we've frequently raised in the monetary considerations. It does, however, contain a section called Anti-Retaliation Protection for AI Whistleblowers. And that section protects a whistleblower, someone who develops or deploys AI, and provides information regarding AI security vulnerabilities or flaws, or conduct that the whistleblower reasonably believes to be an AI security vulnerability or an AI violation. And it protects that whistleblower from a range of retaliatory conduct, which can include demotion, suspension, threats, harassment, or ultimately termination. Individuals that believe that they've been retaliated against can seek relief by filing a complaint with the Secretary of Labor. If the Secretary of Labor does not issue a final decision within 180 days, and the delay is not due to the bad faith of any individual, that whistleblower can then bring an action in any federal district court. And some of the relief that's contemplated could include reinstatement, double back pay plus interest, and compensatory damages, including attorney fees and costs. Finally, and this ties into some of the points that Mehdi had raised, the legislation provides that the protections and remedies offered cannot be waived by contract or condition of employment, including mandatory arbitration clauses, which would impact the whistleblower's right to bring suit in federal court. This is definitely interesting proposed legislation, and it's one that we're going to continue to monitor. The bill remains at the committee stage. Its prospects for passage are uncertain, but regardless, the fact that it was being introduced alone signals the growing bipartisan interest in protecting employees in the AI sector.
Very interesting. Thank you, Kamil. You mentioned that this bill is bipartisan. Is it unexpected to have bipartisan support for AI whistleblowing protection?
It's hard to say, although we have seen interest in AI regulation from both the current and the prior administration. In fact, the prior administration had likewise been concerned about the misuse of or misrepresentation of AI. On October 30th of 2023, President Biden signed Executive Order 14110, titled Executive Order on Safe, Secure, and Trustworthy Development and Use of Artificial Intelligence, which, by the way, I believe was the longest executive order to date. That executive order observed that despite the potential for AI to solve pressing problems and benefit society, it also came with substantial risks. Accordingly, the EO directed the Secretaries of Commerce, Energy, and Homeland Security to coordinate on developing industry standards for AI, which could include appropriate procedures and processes to enable developers of AI to perform tests to confirm that their systems were safe, secure, and trustworthy. Meanwhile, the executive order also directed the Secretary of Commerce to require companies developing certain types of AI models to provide reports and records to the federal government. And these reports were to explain how the models were trained and developed, and to include details on cybersecurity and other protections that are in place.
Mehdi, is that executive order still operative?
It is not. The Trump administration revoked that executive order in January. In its place, President Trump issued an executive order titled Removing Barriers to American Leadership in Artificial Intelligence, which described AI as an example of American innovation and dominance and eliminated existing federal policies viewed as barriers to American AI innovation.
Thanks. Let's switch gears and discuss some recent enforcement actions involving AI. Kamil, could you please discuss AI washing?
Certainly. So AI washing refers to situations in which a company makes false or misleading statements, essentially exaggerates about its use of AI and the capabilities of its AI program. And it does so to make those capabilities appear more sophisticated or intelligent than they actually are. So the first AI washing enforcement cases that we've seen under the Trump administration have been brought in April by SEC and DOJ, and in parallel civil and criminal actions. In particular, there's a case involving Nate Inc., where Albert Sandiger, who is the CEO of Nate Inc., was charged with making false claims about his company's AI technology and its operational capabilities. According to the indictment, Sandiger founded an e-commerce app called Nate, and it was supposed to streamline the online shopping experience by completing retail transactions across several e-commerce sites through AI. Sanager, the CEO, claimed that Nate could transact online without human intervention. As a result, he allegedly fundraised over $42 million from investors, which is based on those representations about Nate's use of AI. But Nate allegedly relied on overseas teams of contract workers, so human beings, to actually manually and secretly process the e-commerce transactions. So it was allegedly the use of humans rather than AI that was doing the work. In DOJ's press release, DOJ claimed that Sanager had, quote, misled investors by exploiting the promise and allure of AI technology to build a false narrative about innovation that never existed. DOJ charged Sanager with securities fraud under Section 10B of the Securities Exchange Act of 1934 and Rule 10b-5, as well as wire fraud. There was also an SEC case, as noted, that similarly had 10B and 10b-5 allegations, as well as alleged violations of Section 17A of the Securities Act of 1933. So AI washing enforcement is part of a broader regulatory trend. We've heard about greenwashing and ESG washing. It's in the same kind of nomenclature, AI washing, where you're making exaggerated statements about what you're doing with respect to AI. And notably, it's not limited to startups. We've seen press coverage about public companies and financial institutions that have also faced scrutiny with respect to AI-related claims. And the FTC has likewise warned against deceptive AI marketing, adding another layer of risk. So it's something that we are definitely paying attention to as companies are making claims with respect to their AI capabilities.
Thanks, Kamil. That's very interesting. Let's wrap up. What are your takeaways?
Well, it's definitely a rapidly moving space. And as with many areas, it's no surprise that whistleblowers are seen as an important tool to help identify and quote, root out any kind of misconduct. We'll continue to monitor the ways in which legislators at federal, state, or local levels seek to protect employees who blow the whistle on potential misconduct in this area of innovation. And I hope to have more of these discussions with Mehdi in the future.
Thanks, Kamil. Totally agree with you on all of that. And on AI washing, we will continue to monitor whether the DOJ and SEC under the Trump administration bring more AI washing cases and whether the administration issues guidelines on AI innovation. Companies in the AI space seeking to fundraise or make public filings should avoid inflated messaging about how AI is used or developed in their businesses to reduce the risk of an AI washing claim.
Thank you for listening to S&C Critical Insights. This concludes the substantive portion of our series on whistleblowing, and we hope you are able to tune in to our prior episodes and join us for a wrap-up episode to come. For more information about our practice, please visit us on the web at www.solcrom.com.